Number 17, the people of the state of New York versus Dennis O'Kane.
May it please the court, I'm Chris Horn for the appellant, the people of the state of New York. I'd like to reserve 2 minutes for rebuttal, please.
You may. Mr. Horn, is it your position that on an ineffective assistance of counsel claim that the court is foreclosed from looking at certain portions of the record?
Well, not precisely. I would say that the rule in that instance is if the court discovers an issue on its own that has not been raised by opposing counsel, and in this case it was waived in the court below, it was not preserved, it was consented to, and then it was abandoned on the appeal. Sure, the court can look at the issue, but the first thing it has to do, just as a matter of due process and fundamental fairness, is give the parties notice of the issue and give them an opportunity to be heard.
There are scores and hundreds and thousands of appellate decisions probably reviewing ineffective assistance of counsel claims. And when that happens, and the court, you agree that the court is required to look at the totality of the representation, right? So, here, are you saying that county court was not permitted to assess defendants' allegations of ineffective assistance and say, well, in and of themselves, they don't get you over the hump, but when you add to it this problem that's right there in the record that I think is absolutely abominable, you get ineffective assistance of counsel. So when a court does that sort of thing, they have to go back, send it back and say, before I can consider this piece of the record in determining overall representation, I have to give you an opportunity to be heard on that? Is that what you're saying?
That's exactly what I'm saying.
But would you agree that courts generally don't do that?
I've never seen a situation where you had a consented to, waived, abandoned issue addressed by a court on its own without asking for further briefing.
Well, assuming that the court wasn't saying that it was error as a matter of law, but was a piece of the ineffective assistance of counsel, does that not change?
It does not, because it's the defendant who bears the burden of showing that counsel lacked any legitimate or strategic reason for the conduct that occurred. So if you assume for the moment that, well, that was a terrible idea to consent to the annotations on that verdict sheet, you still have to show that there was no legitimate reason to do so. And particularly under the facts of this case, if we're not talking about general matters, under the facts of this case, there was absolutely a legitimate reason why she consented to those annotations.
Why isn't your due process concern solved by your ability to move to re-argue or have the matter reheard?
Well,
you
first
actually
of all,
had an oral argument.
You did.
excuse me?
You had an oral argument. You had an opportunity to make clear to the court your position.
Well, we had an oral argument on the appeal, at which point this issue was not addressed. Defense counsel didn't raise it. The judge didn't ask about it. There was a motion to re-argue in which I attempted to raise the issue, but I was immediately cut off, and the motion to re-argue was denied.
But you
So there was no
submitted,
briefing
did
on
you
it.
not submit, you didn't submit any papers on the motion to re-argue?
I did submit submitted papers on the motion to re-argue, but he denied the motion to re-argue, so there was never a full briefing.
Well, but that's
of the
like
issue.
having raised the issue the first time and the judge rejected it.
Well, no, because he didn't address it. He still
We're not
didn't
saying
address
he
it. He
didn't read the-
denied me the right
Well, how
to
do you know he
have.
didn't? How do you know the judge didn't review it and, again, reject it?
Because he
If they're
says
all
he didn't.
denied the motion,
He
right?
denied the motion to re-argue. He didn't grant re-argument, in which case there would have been a
But don't
re-argument
courts
of the issues,
typically,
and then he would have considered
courts, when they are presented with a motion to re-argue, don't you think that they normally read the papers, and when they deny the motion to re-argue, it's because they conclude that it's not, doesn't have any merit?
Well,
I think what you're
Counsel.
suggesting is that to do that, he would have had to grant re-argument and adhere to the result, as opposed to just deny.
But
Usually isn't the format, usually you grant re-argument, and then upon further review, it'll be either denied or not. And you'll
If
be
he
allowed to
denied
make,
it.
you'll be allowed to make oral argument, make a record of what you want, and that's usually the great advantage of granting re-argument. At least you can make a record and preserve these issues and bring them forward.
Correct.
But counsel, I'm sorry, I'm not understanding your position. I'm reading in your brief, county court scheduled oral argument on the people's motion to re-argue. At oral argument, county court excoriated the people as misguided and called the verdict sheet patently absurd. You tried to argue. So there is an oral argument
I agree
on
there's
this.
an oral argument.
And if a judge is telling you your position is patently absurd, I think they read your papers.
I 100% believe he read my papers, but he did not grant re-argument on the issues. He simply denied re-argument, so it was never briefed. And the biggest problem in the entire thing
Well, if you
is
submit on the papers and you don't get an argument, have you not been heard?
I've been heard on whether or not there should be re-argument. And he
And-
denies
Well,
it. He
and
denied
from the
re-argument.
judge's statements, it's clearly a rejection of your position. More than once, apparently, according to your brief.
If Your Honor wants to view it that way, sure, I disagree. He denied re-argument. We weren't heard on the merits. It was never briefed by the other side. And the biggest problem in the entire thing is the burden has been shifted to us in this instance. They have the burden of showing that there was no legitimate reason to consent to that verdict sheet. There are abundant reasons why you would do it, because it was perfectly consistent with her defense. Her defense was, the entire time, all the way through, was yes, he committed these acts, he did these things, he got on the stand and admitted, I did all these things. But he lacked the culpable mental state to be convicted.
I don't understand how that shifted the burden. How did it shift the burden? You mean because you've got a burden on the re-argument motion?
No, the burden to show that counsel lacked any legitimate or strategic reason for his conduct. If you can raise waived, abandoned, consented issues, if the judge can do it by itself without having people brief it, and nobody ever shows, the judge never even tried to show that there was no legitimate or strategic reason for his conduct at any point. He just said, this is the worst, this is ineffective assistance of counsel at its worst. That's ipsa dixit, that's not legal reason.
What if county court said in its decision, instead of focusing on this issue that was waived, unpreserved, whatever, that taken by themselves, the claims of ineffective assistance that the defendant has raised, do not rise to the level of deprivation of meaningful representation, but in viewing the record as a whole, I find that there was ineffective representation, and doesn't refer to that issue. What happens then?
We lost at that point. But that's not what he did. And ultimately, we're getting sort of away from the text of the decision. The decision is not about ineffective assistance of counsel. He doesn't focus on ineffective assistance of counsel.
Well, he certainly said in the argument on your re-argument motion that that's what he was focusing on when he made his decision.
Sure, but he's rewriting the decision, and he didn't grant re-argument, so that's not a new decision. But here, when you read directly from the decision, it says, here it is manifest that the cited annotations on the verdict sheet were not authorized by CPL 31020 and constitutes reversible error. He's saying that the annotations on the verdict sheet constitute reversible error. Not that it's ineffective assistance of counsel. He talks about how it's akin to a mode of proceedings error, but it's not. This court has said it's not a mode of proceedings error.
Well, he said it was akin to, as I read it, what he was saying is that this is such an egregious error on the part of defense counsel that it's clearly ineffective assistance. That's how I read what he was saying.
Except that it is not error. People versus Angelo, this court said, when counsel consents to annotations on a verdict sheet, no error occurred in its submission. There was consent. There's no error here whatsoever. He wouldn't have done it. That's the standard that's being applied, is whether or not he would have done that. That's not the standard.
Whether he would have consented. Is that?
Yeah, he's been a defense attorney his entire career. He knows he wouldn't have done that under those circumstances. But there is a perfectly good strategic reason why it was consented to. And ultimately it worked. There were 2 acquittals on 2 counts where the defendant admitted to the underlying conduct.
So is it possible that county court erred in finding that there was ineffective assistance of
I
counsel?
100% agree that he erred there. And that's the second part of my argument. You got it wrong in the procedure, but ultimately the result is also incorrect, and we'd ask the court
Why
to
weren't
reverse
those annotations prejudicial?
Why weren't they? Because the defendant testified to all of the conduct that's listed in those annotations. They weren't contesting the conduct that is listed in those parentheticals. He took the stand, he said, yes, I did that, but I didn't intend to harass or annoy her. Yes, I did that, but I didn't intend to violate a court order. So by her mind, there's absolutely no prejudice, and she
But
specifically
you're not
said...
saying, you're not saying without the waiver that those annotations would have been proper, are you?
No.
Oh,
Without,
okay.
no,
All right.
without
I just wanna
consent, absolutely.
No, I got it.
But particularly as far as her strategy is concerned, in her summation at page 787 of the trial transcript, she says to the jury, each charge has to rise and fall on its own, can't be decided collectively. You have to look at the evidence that relates to each specific charge. You're free to render different verdicts on each specific charge. She was focusing them on those events. So she wanted that in front of the jury. She wants them to know that this one's about 35 emails. This one's about an incident in court. This one's about yelling, I love you out the window as he's driving by. She wanted that in front of them so that they would focus on the individual acts and not the entire holistic case and find him guilty on everything, and it worked. She got an acquittal on 2 counts. It was not an effective assistance of counsel.
Thank you, counsel. Counsel? Why wasn't it good strategy for her to seek to have the verdict sheet annotated and point the jury to the individual charges?
An excellent question, Your Honor. If I may, my name is Paul Edwards. I represent Dennis O'Kane in this action. County court actually addressed that issue in its decision. The county court decision, when it's describing the trial counsel's consent to the verdict sheet, says that the point made is that defense counsel utterly failed to recognize, let alone grasp.
Yeah, but where is there any support in the record for that conclusion? And at what point did county court give anybody an opportunity to address that issue?
With respect to the first part of your question, I believe that this is Judge Lynch's finding based on the record as a whole of trial counsel's performance.
Well, but there has to be something to point to in the record that would support that conclusion, doesn't there?
I would
You
say
can't
that
just make it up out of thin air.
No, I agree. However, in the context of the court's decision, when Judge Lynch says it is the court's judgment that consent to the verdict sheet evidences ineffective assistance of counsel at its worst, the next thing he says is the point made is that defense counsel failed to recognize, let alone grasp.
Right, I
the
understand
annotation
that, but
restrictions.
I'm not aware of anything in the record that would, as a matter of fact, the record indicates that there was a discussion between defense counsel and the people and the court, and it was, and it was, you know, the whole thing was discussed, and it seems to me counsel made a conscious decision. Whether it was reasonable decision or not is another question, but I just don't see what there is in this record that would justify a legal conclusion that counsel didn't know what she was doing.
Well, the record doesn't contain whatever that earlier conversation was. As you point out, Your Honor, there's a statement in the trial record where it says this was the subject of a previous discussion. We don't know what that previous discussion was. The record simply doesn't reflect that. And he basically says, all set, counsel, and she says yes.
Right.
And that's what we've got.
So the only annotations I think that you're complaining about are the parentheticals that describe the evidence that relates to a particular charge, is that right?
That's correct, Your
So
Honor.
the dates are okay, and the statement of the penal section code and description of what that code section is, that's all okay? Those aren't extraneous annotations?
That's correct, Your Honor.
So
That's-
could you take any one of them you want and, well, before you do that, are you making any argument that the information, the annotation in any of the parentheticals is factually incorrect? That is, there weren't 36, approximately 36 calls, or only 2, and it's misleading for that reason.
No, they all had a basis in the people's evidence. The problem is that they're being reflected in the verdict sheet itself, not in, you know, in the people's arguments and the people's accusatory instrument.
Right, so that it's not that they're inaccurate, it's that they don't belong there.
Correct.
Okay,
I
so
think the way that
then can you explain why their existence on the sheet caused any actual prejudice?
Well, whether they cause any actual prejudice is a little tricky because, of course, jury deliberations are not recorded. And one of the reasons that, in general, there is no harmless error analysis of verdict sheet notations is because we can't assess what prejudice occurred
And so is
Were
in a
any-
jury deliberation.
Were any of those factual allegations, or I shouldn't say were any of them, were those the same factual allegations that would have been, that were in the indictment, or would have been in an indictment?
They would have been in the accusatory instruments, but the big difference there, Your Honor, if I may, would be there have been cases where, let's say, an accusatory instrument has been given to a jury.
Exactly.
That's coming from the prosecution, though. That's not coming from the court. The verdict sheet is coming from the court.
But didn't the court give a jury instruction, a limiting instruction on what they were to do with that?
Yes, it did.
Okay,
Yes,
so
that's correct.
does that not compensate?
I think because there is no harmless error analysis of the verdict sheet notation errors, I don't think that it does.
But we're not talking actually about the verdict sheet error. We're talking about whether counsel was ineffective, right?
You agree with that, that that's the basis for the county, it's somewhat confused, but that the basis for the county court holding is a finding of ineffectiveness?
It's a finding of ineffectiveness, yes, absolutely. And I just think it's important to clarify something, because in the people's brief, they say that Albany County Court rejected every single argument that the defense made, and that's simply not the case. The county court decision did agree with a couple of points that were raised. In fact, let's put it this way, there were 7 examples of ineffective assistance of counsel that were raised on the appeal. 2 of those, county court agreed with the defense that
And those are what?
problem. Those 2 were an error during cross-examination, that trial counsel failed to control witnesses adequately. The county court said it is manifest that defense counsel should have been more proactive in moving to strike the inflammatory remarks, which were not responsive to the questions being asked. The other one was an error which occurred during summation when trial counsel failed to object to a remark made by the prosecutor, "Tell Mr. O'Kane this is enough."
But
And
would
Judge
those,
Lynch- I'm sorry.
either individually or together, have been enough? Did the county court say, putting aside the annotations, these 2, or either one of these is enough to establish an effective assistance of counsel?
We know the summation one he found would not have been, because what he said, what Judge Lynch said, was clearly such comment was improper, but does not necessitate a new trial. So that error standing alone would not have necessitated a new trial. However, it is a factor, and there were, again, Judge Lynch found 2 examples of ineffective assistance of counsel where he agreed with the defense. He also then found a 3rd example, because he was doing exactly what People v. Baldy requires him to do, which is to look at the totality of counsel's performance. I think it's important to...
So that's the nub of it, isn't it, really? How far can the judge go in examining the record? And do those issues have to be raised so counsel can properly respond? So can an appellate court search the record, find error, and based on that error, which no one's briefed and no one's argued, make the determination? It really isn't a question of the error itself here. We're really talking about a different principle, aren't we?
We are, in a way, and this is, let's put it this way, this happens to defense counsel all the time. When we're arguing ineffective assistance of counsel, we will argue, let's just take an example, that trial counsel screwed up the summation, okay? And we'll get a decision back from the appellate court saying, I find the totality of the representation was meaningful representation because counsel made opening statements,
Yes,
participated in
but that's
questioning.
the standard, and your burden is to show otherwise. So
Yes,
you may
but-
do that by coming up with an exclusive list, or you may do that by showing these are the egregious examples, and by the way, otherwise it shows incompetence across the board.
We're never given.
But there's
any
no
sort of
surprise on the standard, that it is the totality.
Exactly. That's exactly correct, Your Honor. There is no surprise. Once ineffective assistance of counsel has been raised, it's no surprise to either party.
So what's
that
the
all
bottom
of
line here?
Counsel's
If
conduct will be
we-
looked at.
If we think that there could be a strategic reason for allowing the annotations, to defense counsel's consenting to the annotations, what happens?
Well, I suppose that might depend on whether that's a finding of fact or a finding of law by Judge Lynch. I mean, Judge Lynch said that he finds that there would have been no comprehension of the issue by the trial counsel. I'm not sure that's subject to review as a finding of fact. One thing I
Just to
do
be
wanna
clear,
make-
your position is that the attorney could not consent, and that our law does not allow attorney to consent to these annotations. Is that your
It's-
position?
No, it's that the consent of trial counsel was ineffective, an example of ineffective assistance of counsel.
So
Before my time-
doesn't that require understanding the motivation? Why isn't that something that has to be resolved through a 440 motion?
Why, isn't it something that has to be resolved?
Yes,
resolved
rather than
through a 440
speculate about the
motion?
motivation.
Judge Lynch doesn't directly address that, but based on the wording of his decision, it seems clear that his finding is that counsel simply didn't understand the issue.
Isn't it that you just can't believe a lawyer would do such a thing? Which is a little bit different from the finding I think you're trying to argue for here.
I'm not sure if that's entirely
And
accurate.
even if that was a finding, this court can review it for record support, can we not?
Absolutely. Before my time runs out, I do want to address just one issue, and that is there was some confusion about whether there was oral argument on the motion to re-argue. Yes, in the appellant's appendix, that does appear. It's like 4 pages of transcript from pages A80 to 84, 85.
The way I understood that argument was that you make a motion to re-argue. The motion to re-argue is separately granted. So there was an argument on whether or not to grant the motion to re-argue, which I assume was denied. If the argument had been granted, then you would have briefed it. However, the court would have set out a schedule for it, and you would have went forward maybe a week from now and then argued it. That's the normal procedure, as I understand it.
It is, but during that colloquy, there was some discussion of the underlying issue as well.
Thank you, counsel.
Thank you.
Mr. Horn?
Very quickly, the biggest problem with the totality of the case approach that he's taking, and I agree that is the standard that you review the entire thing, you do it under the totality of the case. It is not enough to simply allege ineffective assistance of counsel and then shift the burden to us to cull through the entire record, examine every decision that counsel made along the line, whether it's consent, whether it's waiver, whether it's calling one witness over another witness, and coming up with legitimate reasons why that was done. And that's what he's suggesting can happen here. He abandoned the issue on appeal, but we were supposed to somehow know that that was going to be an issue and brief it. And a lot of this can be avoided. I would ask the court to adopt its reasoning in Masicki versus Caradonna, where it said, for a court to decide an appeal on a distinct ground that it winkled at wholly on its own poses an obvious problem of fair play. The courts are not in the business of blindsiding litigants who expect them to decide their appeals on rationales advanced by the parties, not arguments their adversaries never made. That's what happened here.
Thank you, counsel.
Thank you.